promulgation of the new constitution, this particular section should actually remain as proposed, that the person to hold that office will have to be qualified for appointment as a judge. Then we have clause 2, a proposal to amend, so that when clause 1 comes into force, then clause 2 would protect the person holding the office for the remainder of the period of that period of the term of that office holder. We did not have any particular problem with this, save that it is clear in our laws, cardinal principles of legality cannot approbate and reprobate at the same time. Number 2, there is no point in guaranteeing which cannot be executed otherwise. Clause 3, which deals section 2, actually deals with an accrued right of the chairperson holding the position now. That person has a contract which cannot be terminated through this legislation or any other legislation. The fact remains, the person will serve for the remainder of the contract before it comes to an end. So our only problem with this clause was what would happen once that person serves the remainder of the contract period. Section 2 would become a dead letter law. It would not be protecting anyone else from that period until this act is repealed. So we asked ourselves, is there any need of legislating on what we would consider in legal terms as obvious? Because you cannot interfere with this contract until it comes to an end. And that is the fact in law. So we proposed as follows, that we delete that section so that it does not remain in our statute books after the chairperson completes the term, where whatever number of years are remaining. It would thus be a tidy statute which does not have any dead letter provision in it. The assurance is that under our laws, which laws are wide, whether Commonwealth, whether our own practice here, laws of equity, principles of equity, you cannot interfere with an individual's accrued right unless that person consents or agrees to the interference. Therefore, the position of the chairman is actually secured until the term is over, after which then the rest of it will kick as per clause 1. So, in brief, we are saying, let us allow clause 1, clause 2, which proposes to amend section 5(1), but we can delete clause 3, which proposes to amend section 2, so that we do not have to keep this provision in our laws after the term of the chairperson in office expires. May I make it very clear as I conclude that the current chairperson need not be worried. He is protected by the law. All the laws protect him, the laws on contract, the laws of employment, the laws of equity, the doctrines of equity, and even our common law practice. He is protected, he's not targeted. But let's make it very clear that every Kenyan is looking upon the EACC to deliver on corruption cases. This is why we are putting the standard on the chairmanship to be quite high, so that that person can answer on issues of law where these come into play. Today, the commission may not have any advocate apart from a cutlery of qualified advocates in the staff. These do not sit in the commission, and when the commission is called upon to go and defend itself, sometimes it may be difficult for the commissioners to express themselves as lawyers. Therefore, we do propose that clause 2, which amends section 5, be allowed by the House, and also the House agreed with us in spite of the provisions in the NADECO report that we should not touch any provision, we do convince this House that Clause 3, which amends Section 2, would soon become dead letter law. With those remarks, I beg to move and I request the Deputy Majority Leader to second this. Thank you very much.
Honorable Speaker, thank you very much for giving me this, and also to thank the committee for a job well done in looking at that law. Honorable Speaker, it is very important that progressively as a democracy, we need to review the laws and also look at how the functioning of the law that has been in place has impacted either positively or negatively on the country. And therefore, a review of the Ethics and Integrity Act that we have here today is very important, especially to look at the qualifications of the office bearers, especially at that high level. Honorable Speaker, I think it has been seen that there is an issue in having a non-lawyer or a non-advocate to serve as chairman, and it has had repercussions on the commission. And therefore, it is very important that we look at that and see, probably, when we put somebody with credentials in law, somebody who is qualified as a judge of the High Court, to be the chairman of the Ethics and Integrity Commission in this country, we are raising the bar and actually saying that we are serious about fighting corruption in this country by ensuring that we have a board that has people that qualify to sit there. Because the work of the commission is usually nitty-gritties of law that spread across many. So as you chair that board, Honorable Speaker, it is very important that the chairperson, the person sitting to chair the board, has the prerequisite qualifications to ensure that he can conduct board meetings and is able to follow through whatever is happening. Honorable Speaker, I want to support the Honorable Murungara on the issue that although the current chairman may not have those qualifications and assist there, because we know he's a man of integrity, we know he's a man that can be counted for to stand for this organization and for Kenya, and to ensure that the fight against corruption in this country is taken to the next level. And we have tremendous respect for him. But the law provides that as long as he still sits on the board, we'll allow him to finish his term, and so that as the law kicks in, the new law kicks in, he can now pave way for a new chairman. So I want to assure the Commission that there will be no disruption as we approve this law, but it is important that progressively as our country, we look at the laws, we look at what needs to be done to farm the law so that we are at the forefront of fighting corruption, and fighting corruption with a board that has the prerequisite legal requirements to actually fight. But I also want to thank the Commission that is there for the job that they are doing. I think for the moment, I think Kenya, in terms of fighting corruption, we have had high-profile cases go to court. We have had high-profile investigations going on, and I think a good job is being done at the Commission. I also want to thank the current CEO who is there for steering this organization and taking it away from politics and ensuring that it's doing some professional work. And therefore, I stand to second and ask members to support this amendment so that as going forward, we strengthen the Commission and make sure that it has teeth to bite and also take Kenya to the next level in terms of fighting corruption. I thank you, Honorable Speaker.
Honorable members, I now propose the question that the Ethics and Anti-Corruption Commission Amendment Bill, National Assembly Bill number 11 of 2024, be read a second time. Yes, Honorable Karoli Omondi.
Thank you, Madam Speaker. I'm looking at the clock, and I'm not sure we can exhaustively debate it, but I want to have a go at it, and maybe if you will allow me to have a first bite when it comes up for debate. Actually, Madam Speaker, I rise to oppose this amendment. I rise to oppose it because I don't think it is well aligned with the structure, the legislative structure of the Commission and the provisions of the Ethics and Anti-Corruption Commission Act. Madam Speaker, let me begin by giving some examples of the most efficient and effective anti-corruption agencies in the world. Number one is the Corrupt Practices Investigation Bureau of Singapore. And Singapore is always rated as the least corrupt country in the world. That particular agency, as a matter of fact, is headed by a senior police officer, not a man with the qualifications of a judge of a high court. The second most efficient anti-corruption agency in the world, and a country known for least corruption, is Sweden. And they have the National Anti-Corruption Police Unit, headed by a police officer. Why am I doing so? Because the idea behind this proposal for amendments is that EACC is not able to conduct effective investigations because they do not have a legal mind heading it. That is, nothing could be further from the truth. The commission, the Australian National Anti-Corruption Commission, is headed by a judge, but for a very specific reason. But now, let's go specifically to the Anti-Corruption Act that we have in Kenya. If you look at Section 7(2) of the Ethics and Anti-Corruption Act, the commissioners, which is the chairperson, and the members actually serve on a part-time basis. They are not full-time employees of the commission. So to try and appropriate inefficiencies to them is actually to miss the point. They are part-time employees of the commission. That is Section 7(2) of the Ethics and Anti-Corruption Commission. How that affects the work of the Commission should have been the focus of any proposed amendments. Secondly, if you look at the mandate of the EACC, it is broader than criminal investigations. Look at the functions of EACC. They are much, much broader than investigations. There's suppression, there's detection, there's